So hello, everyone. Thank you for being here. My name is Jonathan, as Adam said, and I am an econ alumni. So a little bit about what I did after university. I ended up being a laborer, broadly speaking, for a number of years. I coached hockey a little bit as well. I did some landscaping, and I think generally the point is that I didn't really have a set direction on where I saw a clear path for me to go. I had a couple of goals in my mind and my life that I wanted to try and achieve. I never hated school, so going back to school and getting further education was always something that I considered and sort of expected to do. And for the better part of my life, to a degree, law has interested me. So this was a goal that I had thought about during my undergrad. I think for a large portion of my undergrad, I had a number of people tell me basically, sorry, you should choose a different path because it is competitive, it is difficult. But I think if you're going to take one thing out of this discussion today, it's if you really want something and you put your mind to it, you can achieve it. And I know that's a little bit cheesy and it's a little bit cliche, but I am living proof of that. I took a unique path. I took a path that many people wouldn't have taken. And at the end of the day, I got to where I wanted to be, and I'm happy for it. So yeah, with that, we'll start on the next slide on how to become a lawyer in BC. So there's a few steps that you have to get through, hoops that you have to jump through, that kind of stuff, and ultimately becoming called to the bar. And it all begins with obtaining a qualifying law degree. So I'm going to talk about that a little bit more in a minute. This is sort of the overview of what we're going to talk about today. Once you've got that degree and you apply for what's called your articles, which is sort of your hands-on training in the legal field before you become a lawyer, there's a character and fitness review. For the most part, this is a formality. Having said that, some people do have records and they still can become lawyers. People make mistakes in their past and they move on from that. But it's something that, I think for obvious reasons, if you're entering the field of law in a position as a lawyer, they want to know if you have a criminal past or what may have occurred. And that's part of the character and fitness review. And again, there'll be a little bit more on that later. Then really the articling is sort of the substantial part of your post-law degree work that gets done, and this is where the real challenges are, and I'll get more into that as well. It takes a year, and it includes what's called PLTC, which is the Professional Legal Training Course, which is a 9-week course that is done at the Law Society or through the Law Society, and then the 10th week is your bar exam. So the bar exam and your articles are sort of intertwined. From a timeline perspective, you can think about that as the two events that occur within a year. And then if you pass all of that and you pass the bar exam, then you get called to the bar and you're a practicing lawyer in good standing. So with that, we'll move on to what qualifying law degrees are. Sorry. So I think the most common path that people expect to go to become a called lawyer in Canada or British Columbia in particular is through one of the Canadian law schools. And in order to do that, you'll for the most part, you'll get a JD or a Juris Doctor. This is the qualifying law degree. Formerly, it was called the LLB. And they, I don't think much changed other than the name, but this is the first step in entering into the pathway to become a called lawyer. And the reason I'm focusing on a JD is that some law schools offer LLMs, which is a master's level law course. That is not necessarily a qualifying law degree. Some of these degrees are thesis-based. It's more theoretical, and it would be open to somebody who's had an undergrad. Obviously, it's a master's level course, but it doesn't allow you entrance into the legal profession. That is the JD. And I believe all Canadian law schools now have their programs as JD. Again, as I mentioned, that was previously LLB, and different schools changed that at different times. So that's the Canadian way. There's also the ability to do this through a foreign jurisdiction, which is what I did. I went to school in England. It is a common law country as well. So if I wanted to come back to Canada, Australia, or America, they're all common law jurisdictions. So you jump through some hoops coming back, but it allows you to come back because it's the same basis of law. Now, the caveat is Quebec. Quebec is a civil law. Same with Louisiana, I believe, in the States. It's a civil law system, as is most of Europe. So those are the two predominant legal systems in the world, in the Western world, I should say, and they are distinct. So, if you wanted to go away and practice in Quebec, England is probably not the place to do it. Again, it's not necessarily impossible, but it would require a lot more work to come back and have that be acknowledged as your qualifying law degree, which again is why I say foreign students must obtain a law degree from a common law country. Now, that may not be an absolute, but I would advise anybody who's considering going overseas to study law to go to a common law country. Coming back and ensuring that the degree you obtain is a qualifying law degree is your responsibility. There is, I believe, a link at the end of the PowerPoint, which I provided, which lists some of the approved schools, and that's through the NCA website, which again, there will be more on that later on in these slides. But again, the important thing is if you do make the step to go out there, it is a big financial decision. On top of that, it takes a few years of your life where you're going to be focusing and working. You want to make sure that you can come back and you haven't closed the door to a career path from you. So that's just a note on the qualifying law degree. So we can go to the next slide. So if you're going to try for the Canadian law school route, which again is the most common path, I think, for undergraduate students who are thinking about going to law school, you have to write the LSAT, which I believe is sat 3 or 4 times a year. And then applicants are predominantly determined by their overall GPA and their LSAT score. When I was looking into this, which was probably around 2014, maybe 2013, schools hadn't really gone to a holistic approach for applicants. I think they started considering that a bit more and moving away from strictly what your grades say, what your LSAT score says, because I think more and more universities are acknowledging that students have more to offer than just that, or there's more to them than just that. And with that, you see there's a note on the slide here saying that there's alternative application pathways for discretionary applicants and Indigenous applicants. Now, part of the reason that, and this is just a bit of background on me, part of the reason that I had a hard time getting into a Canadian law school is that my dad passed away while I was doing my undergrad. So I had a pretty significant family event occur that undoubtedly caused some decline in my grades. I'd love to sit here and tell you that I was a math whiz and I was acing everything up until that moment, but the truth is I was never really good at math. And if you are in the econ program, you'll know how fundamental that is. So all of that being said, I had the ability to apply through the discretionary pathway. And what that does is it allows your application to go through sort of a separate vetting process where the board will look at you a little more holistically as opposed to just strictly through your GPA or your LSAT. ultimately my LSAT score wasn't high enough to overcome my my deficiencies in my GPA. I hate to say that, but that's the truth. So all of that to say that, you know, if you're looking at this, but, you know, maybe your grades aren't where they are, and you know that, you know, there's a reason for that, I would reach out to the law schools and send them an email and say, hey, this is who I am. This is my situation. You know, what are your general thoughts? They're not going to give you a you know, a firm answer and saying, oh, you know, if you get an LSAT score of this, you're going to get in. It will be vague. It'll be gray, but that's okay. You'll be able to gauge you know, where you may stand if that applies to you. You know, you can also ask them, you know, if you've had a life event, if that would qualify you to go through this alternative pathway for an application. So that's just a bit of background on the Canadian law schools and applying to them. Obviously, my experience was in England. So beyond this slide and what I've said about Canadian law schools, I don't know much more about the application process. I have a little bit of an idea of what happens a bit down the road when you're looking to apply to firms and all of that. And that will come up later in this presentation. So we're good to go to the next slide. Thank you. So again, I went to school in England. I was at the University of Birmingham, which is in the middle of England. It's not too far away from London. And it was a qualifying law degree. So this is something that I looked at prior to going. And I was able to find out that, you know, it would be considered a qualifying law degree. Again, the link at the end of the slides here for the NCAs, for the NCA website, lists the University of Birmingham and lists a number of other universities from other jurisdictions. As I mentioned, and as some of you may know through friends or family that have done this, the most common countries to obtain a qualifying law degree for students going abroad and then coming back are Australia, England, we'll call it the UK. So England, Wales, and Northern Ireland, and the US. And again, this is because these jurisdictions are common law, and the ability to transfer back is a relatively straightforward one. You know, it's work, it takes some time, but as far as obtaining a degree abroad and being able to practice professionally at home, it is relatively straightforward. So again, you know, make sure you do your research on what school you're going to, and whether or not it is a qualifying law degree, before you make any of those big decisions. Next slide, please. So the application process, it was relatively straightforward. All of you are in university, so you've gone through an application process. Some of you may have applied to graduate school or thinking about it. It's not overly different. You know, you submit transcripts, a cover letter, letter of intent. Some may request reference letters. It's that kind of stuff. With England, I can personally speak to, because again, this is where I went. I applied through a program called UCAS, and it was your standard shotgun styled approach. So it's one online portal. You fill out all your information, you submit your documents, you pay one fee, and it allows you to apply to 5 universities of your choosing. You can pay more to add more universities to that list. I went with 5. If this is a path you decide to go down, I would recommend tiering some of your universities. And what I mean by that is do a little bit of research and see what their global rankings are. I think it's QS University Rankings is the global one. The Guardian does a UK ranking for all the law schools, so it's pretty good to get an idea of where they rank as well. And the method I decided was, there was one law school I was going to apply to that was, you know, well out of reach for me based on my undergrad and my grades. And then I picked one law school that was sort of should be my shoe-in, just so I ensure that, you know, I'm making this application, I'm going through the time, I'm investing in it. I want to get accepted to at least one university. So I picked the one that, you know, I figured I'd be able to get into, no problem. And then 3, you know, rank, you know, based on where it is, what you think about the city, what you maybe have heard about the city, anything really. And with this, I got into 4 of 5. So the one that I shot for the stars, I didn't get into. And this actually turned out to be a blessing in disguise. It was the University of Edinburgh, which is a very highly ranked, reputable law school. But what I didn't know before was that it's Scots law. And of course it is, it's in Scotland. But I assumed Scotland, was part of the UK and should have been fine, but it's different. And if I wanted to come back to Canada, having studied there, probably would have taken me another year to have all my credits transfer over. So it's little things like this that I think are important to making this process as smooth as possible. So really do your research, do your due diligence on what universities you like, what it may mean when you come back, what the implications are. And there's only going to be so much information you're going to be able to get at the beginning of this. Like I said, I didn't know about Edinburgh and Scots law and that being an issue until I was already at school. And it was one of those, hindsight's 2020. But you do what you can and you make the best decision you can based on the information you're able to obtain. So for those middle pack schools that you base on whatever your preference may be, I mentioned at the beginning of this talk, I coach hockey, so I've played hockey my whole life. I was a sucker for some good Canadian marketing on the University of Birmingham website, and they advertised that they have a university varsity hockey team on the Canadian page for the page for potential Canadians to come study law. I saw that, and that was my deciding factor to pick that school over the other 3 that I got into. And I don't regret it. And I went over there and I played varsity hockey for the university, and I had a great experience. I got to play University of Oxford and Cambridge, things that never would have happened in my life otherwise. So bring in some of your personal preferences, and it'll help you enjoy your time more should you go and should you end up over there. So that's the application process for England. So we can go to the next slide.
So if I can ask you a question, quick?
Yes, of course.
Casimir, are you willing to share the 5 universities? I mean, not the Scottish university, but are you willing to share the other 4 application or universities that you applied to?
Yeah, of course. So I applied to University of Birmingham, obviously, University of Edinburgh, which I didn't get into. And then there was University of Kent, Exeter, and Leicester. Those were the schools, and they're all relatively closely ranked. And actually, I'm glad you stopped me, because I had a thought that escaped me. Before I decided on any of the schools that I applied to, I wrote their applications department or anybody from the law school that handled applications, or somebody that could point you in the right direction of that, and said, here's my story, here's who I am, here's my background, here's what happened during my undergrad, and here are my transcripts. I just want to get an idea of what where you think I would fall as in terms of a competitive applicant, whether or not I would be a competitive applicant, or politely tell me that maybe don't think about applying here. So that also helped me gauge where I wanted to apply and decide, okay, I think I could probably get into this school. It was based on their response to me, really. It wasn't anything to do with the rankings of the school or anything like that. It was more the human interaction I had with somebody over there about who I was, and sort of just initiating that and reaching out and getting an idea of what they're looking for. They're not going to give you the silver bullet on how to get in, but they'll generally advise you, and they're going to be open to anybody that's got an interest in going to their school. So they'll give you an honest answer. Again, it'll be vague. They're not going to give you a straightforward answer that clearly says in an email, yes, you'll get in, no problem. Because if you don't, that's probably not their decision, and then they'll get in trouble. So I don't think that's surprising. I think you have to take what they say with a grain of salt, and just get an idea for what their response was like. Some of them, celebrated the fact that I was applying and that I was interested and all of that. And then, some of them say, yeah, you know what, like, I'm sorry to hear about your background. I'm sorry to hear about your story. But it may be, you're on the cusp. It might be difficult for you to get in. You're right in that range of, maybe you will, maybe you won't. It's hard for us to say. And again, that is what helped guide me in the decision process. And like I said, ultimately, the final decision came down to that little blurb about having a hockey team and being able to bring my gear out and go play. And a bit on that too is that, look at what the school offers, look at the programs, look at the extracurricular stuff that's available to you. And if something, piques your interest, that may be worth investigating more, because it's good to have another hobby out there other than law, because you'll be doing so much of that anyways. It's good to break away and do something else that you enjoy and really make your experience abroad, as full as it can be. So those are things that I would say you should probably consider if you're going to apply, if you're thinking about it. I think that's worthy of spending the time to figure out. I think we got a question down on the chat, so I'm going to just look at this. Absolutely. I would recommend reaching out to Canadian schools and getting their opinion. I did it as well. Some of the schools, going back to that slide, some of the schools that offer the discretionary pathway. Well, first of all, not all of the Canadian law schools had that when I was applying. And then the ones that did, I had to clarify whether or not I'd qualify. So I think it's important to reach out to them and open up that dialogue. And it never hurts to, have a familiar name going through. Maybe somebody sees the application, maybe, they're familiar with who you are, or whatever it may be. It's worth it to reach out and get their opinion. Having said that, like I said at the beginning of this talk, there's probably a number of people that would have politely said, don't bother, to me, based on my grades, based on what I was coming out of university with. And, that's a bit of a bitter pill to swallow, considering what I had just gone through. I was still mourning the loss of my dad, and it's had and will forever have a profound impact on who I am. And to have somebody from an applications department sort of brush that aside and say, oh, everybody's got something. Yeah, everybody does deal with something, but I don't necessarily believe that's the way to do it and handle that. And again, I think that, where I've got to today is a testament to putting your mind to something, and despite people saying don't bother, or suggesting that it's not going to happen for you, I've made it happen. I took a unique path, and that's fine. Some people are won't want that, won't be interested in that, and that's a personal decision. But I would say reach out to all of the admissions departments and start that conversation. They're not going to give you a straightforward answer or a clear answer, but they'll give you some guidance on where you stand. And I don't think that will ever hurt. So I've got some other questions here that I'm going to just look at quickly. For the high school transcripts and other schools in England, that wasn't my experience. Now, what this may speak to is that schools in England have a number of pathways that you can apply to. And this is something I was going to talk about a bit later, but now is a great time to do it. So I applied to the graduate entry program at the University of Birmingham. And what that meant was I had an undergrad, I completed it, and I submitted my transcripts to the University of Birmingham. So they looked at me more like a master's level student. And the benefit was that their 3-year standard LLB program was a condensed 2-year program. So I was there for 2 years. I was paying 2 years of tuition, not 3. Same with housing and all of that stuff. But if more importantly for me, I was able to come back quicker. And there's a bit more on what that means with the NCAs that I'll get into later. But to go back to the high school transcript thing, in England, you can go to law school and med school right out of high school. For those programs, you would have to submit a high school transcript. I don't think, and I don't know for sure, but I don't think that if you have a university degree, they're going to want your high school transcripts. It may be the case that if you've only done, say, 2 out of 4 years, your standard 4 years for a degree, they may look at your high school transcripts. But if you've graduated with an undergrad and you've completed that program, I would imagine that that would be the only relevant transcripts that they care about. This, of course, would be up to the individual admissions department, but that is my feeling on the high school transcripts. I didn't submit them. I don't even know how I could get them. When I was in high school, it was all paper. So that wasn't an issue for me. That didn't play a role at all. It may, if you don't have your undergrad and you're applying to these universities, because they're going to want to know what you did previously. But if you have your undergrad and it's complete, you're going to provide those transcripts to the schools, and then they'll likely make their determination on that. So then the next question. My GPA and LSAT score. I don't remember what my GPA was. I think it was just north of 3 by the end of it. Conservatively, let's call it 3. And then the LSAT score, I think my best score was a 162, which is a good score. I think competitively, put the grades aside for a second, when I was going through it, and this may have changed, but when I was going through it, you basically needed to get above a 158. And if you're in it and you're doing your LSATs and you're practicing and all of that, you'll know that each incremental point above gets harder and harder to achieve. A 165 is a slam dunk, and that should get you, well, again, when I was doing this, which was a number of years ago now, 165 would likely erase whatever blemishes you may have on your GPA. My 162 was not quite there, competitive, and certainly a good score at the time, but I probably needed a 165 to get over that hurdle. 167, 168, you're probably going to be able to go to whatever law school you apply to, whether that be U of T or UBC, whatever it is. So these are rough ranges from my memory. That's dating back probably about 6 to 8 years. So I imagine that would have changed a bit, but that was what I was roughly applying with. So I don't know if that helps, but yeah, that's from my memory. That's what I recall. And then I've got another question here. No, sorry, no, the English schools do not require the LSAT. Law schools in England got rid of the standardized tests a while ago. If you've written them, you'll know that they're a bit bizarre. There's certain things that as a practicing lawyer, I can look at and see, okay, I see why they're trying to do this. I see why there's some relevance here, but honestly, there wasn't much relevance to what the LSAT score meant with law school. Being a student is different than being good at writing a standardized exam. And that's not knocking anybody that can, do well on those exams. That is an art in itself, but England got rid of the standardized exams a while ago. When I was there, I think Cambridge and Oxford were the only universities that still did their own version of a standardized exam. It was not the LSAT. It was whatever they did, but they were in discussions of removing that as an entrance requirement. And that was in 2016 when I went out there. So a while ago now. I don't know if they have gotten rid of that, but for the vast majority of the schools in England, there's no need for your LSAT. There's no need for any standardized exam. It is just your transcripts, your letter of intent that you submit, and I think maybe a couple references. Okay, I think that gets me up to speed on the questions from the chat. Thank you for those questions. They're great. So yes, back to the NCAA application. So when you come back from abroad with your qualifying law degree, you have to get a certificate of qualification to be able to enter into the legal profession. And for foreign law students, that's through the NCAA process. And there'll be a bit, there's another way to do this as well that I'll get into in a minute. But generally, you have your initial application to the NCAA. You submit your transcripts from the university. They see what you've done. They see what grades you've gotten. They confirm that it's a qualifying law degree from a recognized law school. And then you also provide your CV or your resume. And then you pay a fee like you do with everything. I think it's around $400 or $450 for this assessment to be complete. So after they review this application, they give you an assessment, and we can go to the next slide. Perfect. So this is a little bit of background on the NCA. It's the National Committee on Accreditation, and it is a standing committee of the Federation of Law Societies in Canada. I mean, that's a very boring way to really list what they are. Essentially, the law societies across the country have gotten together and agreed on a standard of what a graduated law student should be able to achieve, what their knowledge base should be, and what they should be capable of. So in essence, they do set the bar for Canadian law schools. There's no NCA assessment if you graduate from a Canadian law school, because the schools in the NCA have worked together to set out what the expectation is. The reason you get assessed when you're coming back from abroad is that the NCA has no idea what you've achieved over there, what your skills are. So that's why they look at the school you went to, your transcripts, the grades you got, and from there they make a determination on what you need to complete in order to be able to apply for your articles. So I think that's it for this slide. So again, here you'll see on the note that applicants are assessed on an individual basis against national criteria for all common law jurisdictions within Canada. Your exams might vary based on grades and experience. So what does that mean? Well, when you come back, there's certain requirements you have to meet, and the NCAA makes you satisfy those requirements by assigning you a number of exams. They're challenge exams, they're pass-fail, and they're self-study. So the NCAA will provide you a syllabus for what you need to know. You go away, you study it however you want to study it. They're open book. You pick a date that you're going to sit down and write it. And then you find out, I think 12 weeks later, whether or not you passed or failed. The exams that you have to do are based on a few things, and we'll get into that on the next slide. But once you complete these exams, you've passed all of it, you're issued a certificate of qualification. And that certificate means that you can enter the legal profession and apply for your articles. So we'll get to the next slide. So there's a requirement that if you study abroad, there's 5 courses, Canadian themed courses, that you have to study on Canadian soil. And they are Foundations of Canadian Law, Canadian Criminal Law, Constitutional Law, Administrative Law, and Professional Responsibility. Criminal law is interesting. Other than that, they're all fairly dry. I hate to say it, but that's the reality of it. These are courses that you'll study no matter where you go to law school. I think their logic behind this is that they are foundational courses and they want some control over what you're learning within these courses. I know previously that Australia, when they first had when they first realized there was a lot of Canadian students going down there to get a law degree to go back to Canada, they created a tailored program that would satisfy these requirements. So you'd come back, you wouldn't have to go through the NCAA process, you were already approved. That's changed, or that changed at least for when I was applying and when I went to law school. That's not available anymore. These 5 courses have to be written on Canadian soil. So whether that's through your Canadian law school or through the NCAA challenge exams, you have to do these here. And then the other requirement to get your certificate of qualification is that you need 3 years of full-time legal study. Now, if you recall, I was saying that I entered the graduate entry program for the LLB, which is the accelerated 2-year program, which got me home a year quicker. I needed to satisfy a 3rd-year full-time legal study. So when I submitted my transcripts to the NCA and they reviewed my grades and my application and all of that, they assigned me 2 additional exams. They're electives. There's a list of them that you can choose from. I think ultimately it doesn't necessarily matter what you pick. If you have a clear path of where you're trying to apply afterwards or an area of law that you want to go into, that may determine what you pick. I ended up taking evidence because I thought it was interesting, and I took what was it? It was Ontario, and I'm shamefully admitting this. It was Ontario civil procedure. I picked this because I had some friends from Ontario that I was in law school with that were doing it as well. And I wanted some people that I could study with virtually. So that's why I did Ontario civil procedure. I'm not in litigation. I'm a solicitor. So my 2 electives had absolutely no bearing on my career path. It's just, it was a means to an end, and they were enjoyable courses to take. So as I mentioned, they are going to assess your application and make a determination based on your grades, based on what program you went into. And an example I could think of is that, if you take, say, contract law abroad and you get a rock bottom grade in it, they may look at that and say, you know what, we're going to assign you contract law because we want to make sure that you have a decent grasp on it before we give you the certificate of qualification to go practice in the outside world and provide legal services to the public. It's pretty straightforward. You're guaranteed to get these 5 courses, these 5 Canadian foundational ones. If you've done a 2-year program, you're going to get assigned another 2. I think they do seatings 3 times a year, I want to say. I did mine in 2 seatings. This is a debate for people and what they decide to do. I had a guy I went to school with that he did all 7 in one go. These exams are held over the course of 1 week. That's a lot. So that means he wrote Monday to Friday, and 2 of those days he had 2 exams in it. They're 3-hour exams. It's a bit overwhelming. I wouldn't recommend that. I wrote 4, then I wrote 3. It's a bit nerve-wracking because you study for the first round and you don't get your grades until a week before the second round. I think I wrote mine in September, and then in the first 2 weeks of January, I think the timeline was, but it worked out. Again, pass, fail, and they're $400 an exam. So multiply the number that you get assessed by the $450 application, and you get an amount that's under $5,000 to obtain your certificate of qualification. So it's another cost. But as you'll see on the next slide, which we can go to, there's another route that is much more costly. So Canadian law schools have also realized that there's a lot of people coming back from overseas that got a qualifying law degree from another common law jurisdiction. And they've created a tailored program to capture some of that. And I don't blame them for doing this. It's a good cash grab. And you also get a degree from a Canadian law school. So it makes sense for a few reasons. But ultimately, this is not a path I chose. And I can get into that in a minute. But it's called the Masters of Law Common Law, generally speaking. Or for short, it's typically an LLM-CL. The reason I'm distinguishing this is that there's LLMs that law schools in Canada offer that, as I mentioned, are thesis-based. They cost about $6,000, but they don't get you any further than you would have been before the master's program. Again, these are for people that I think are interested in law in a much more academic sense. I don't think it means they go in and they become professors for law schools. I just think that it's a graduate level degree that they obtain, and it maybe will give them some specialty knowledge in a field of research or work or something along those lines. The common law masters is the one you're looking for if this is the route you go. I looked at UBC's LLM earlier this week, and the cost is roughly $36,000. So that's a big ticket. That's, on top of, $80,000 to $100,000 in student debt that you're probably going to incur going overseas. You're looking at another 36,000 to do your third year of school here. Now, this will eliminate, most likely eliminate the need for the NCAs. I say most likely because when my friends were applying to this program, the law schools like UBC said that, we can't guarantee, because the NCA reserves the right to further provide you with a further assessment, but it should eliminate the need to complete the challenge exams that I was talking about on my last slide. And all my friends that did this, they didn't have to do anything with the NCA. They didn't do any of the exams. These LLM programs are tailored to make sure you take those 5 Canadian courses and give you some additional credits of work to make sure you have that third year full-time study. So it sort of holds your hand through that process, which can be good. And that's definitely the course that some people want to take. I think most significantly, it gives you access to their careers network, and the advice that you can get from their career staff, whether that be tips on interviews and how to dress and all of that, or access to, they have a UBC at least has a private portal that law firms can post job postings at, that's only available to UBC students or alumni. So there are some benefits there. For me personally, that $35,000 price tag was enough to deter me. I didn't think that it was a worthwhile investment. That was just my personal situation, and that was my decision. My friends that have done it and went through the LLM, they all have jobs, and yeah, I mean, it worked for them. So it's another thing to think about as you're coming to a close from studying abroad. And we're good to go to the next slide.
Jonathan, can I stop you right there?
Yeah, of course.
So, I mean, this is fantastic information, but I'm going to review quickly, if you don't mind. Okay, so whoever's here, I'm going to make an assumption. They're going to finish their degree, we hope. They're going to write their LSAT. Then they're going to determine whether they're going to get into a Canadian law school or not. If they get into a Canadian law school, they're going to finish their 3 years. They're going to article, with whatever firm, and hopefully be called to the bar.
Yep.
Or they're going to get their degree, write their LSAT, apply to law schools in Canada, maybe in the UK as well. Maybe not get into Canadian law schools, get into one of 4 or 5 UK law schools that can be transferred back, common law. Go to the NCA, get their law degree assessed.
Yep.
Right. Likely do the qualifying courses, which is the Canadian content.
Yep.
Then go an article. Once they've passed, then get called to the bar.
Correct. Yeah.
And then the last one is finish their degree, LSAT, apply to Canadian law schools, UK law schools, get into the UK law school, come back, apply for the Masters in Law program, which costs 36,000. Article, be called to the bar.
Correct.
Okay.
Yeah. And just a quick thought on that as well. And this will be, again, to be a personal decision. I know there's a lot of negative information out there about going abroad for law school. And I would encourage you to tune it out. Whether or not that's what your path is, whether or not you end up going to a Canadian law school, that's fine. At the end of the day, when you're done and you're called, that matters a lot less where you went. 25 years from being called, that will matter even less where you went. So I say this because I know a lot of people that have a path in mind as the right path, the correct path, and if there's ever a hurdle or a roadblock or something that prevents them from doing that, they may beat themselves up over it. They may not feel as happy or confident or whatever it is about, okay, I've got to go to an English law school. I mean, I get it, but I think that's, there's a bit of ego in the people that look down upon the others that have a different path. And it is what it is. It's part of the profession. At this stage in the profession, it's about what firm you're at. It's not necessarily where you went to school. It's where you work, and that's very real. But I would encourage you to keep an open mind. And I know for me, when I was doing this, and I was sort of lost doing labor and trying to figure out my path, I wasted probably, I don't want to say waste, but it probably took me, 2 years longer than it needed to end up where I was going. And I could have cut that time out by applying to both Canadian and UK law schools, or Australian or foreign law schools for that matter. And failing to do one or deciding to pick one path over the other, your options are available to you right away. The other note to make is that if your goal is a Canadian law school, and that's good, and it should be, and you're still finishing your degree, start thinking about when you want to write the LSAT, because there's going to be timelines that come into play. And maybe you already know about this, but if you're in your third year, you might want to think about writing the LSAT now, because it's going to take you a few months to prep and then write it at whenever the seating is occurring. And then I think it's for the Canadian law schools, it was every Christmas, like November or December, the applications are due for the following year. So if you wait until you finish your undergrad before you write the LSAT and then apply to a law school, that could be another year, which is fine. I mean, I didn't even seriously think about it until I was done my undergrad. It would, finishing my undergrad was enough work for me to focus on in that moment. And I didn't want to take on thinking about something else. But I know some people are keen to move as quickly as possible. And I also respect that. I mean, that's, in the long term, that will help you get to a better place career-wise earlier. And that's, it's good that you have that vision and that drive. But think about that now. And part of the reason I'm saying that is that, if you try and do the LSAT and trying to get into law school in Canada, it doesn't work out, and then it gets delayed to the next year, and then you're looking at applying for England and somewhere else, it's probably gonna be another year before you head out there. So you may want to start looking at when those deadlines for applications are, and work backwards from there. Okay, this deadline is November 30th. So what do I need to complete prior to that? And figure it out from that point. I was very guilty of, leaving my letters of reference to last minute. I try, and I got better and better, but I would, maybe make the request a little too close to the deadline, and then I find I'm following up with the person I'm asking a favor for. So plan for that. Plan for that, and think about, what your options are, what the pathways are, which hasn't just laid out. And then, if one doesn't work out, what does that mean? Are you going to wait a year and apply to everything again, or are you going to have all your applications lined up and see where you end up? It's just good. And again, this is something I didn't do enough of going through university, was thinking a bit beyond what was right in front of me, and spend the time to really go through the different scenarios of, okay, I've applied to all of these schools. Here's what's happened when I haven't gotten in here, and I have gotten in here, or here, what am I going to do when I get in everywhere? And do I know how I'm going to make that choice then? And so on. So just think about troubleshooting and what that, what the scenarios will be and what the outcomes can be. And that will probably help you navigate this process, with a lot more awareness and understanding of where you're headed.
Perfect. Without interrupting your flow too much here, Jonathan,
Yeah.
there's one step that we discussed last week or the week before, and that was the fact that you already started networking with law firms before you left.
So yeah,
is that a big piece of the pie here, or?
Yeah, and I think that's something that probably will come up in a slide or two.
Okay, yeah.
So if I don't bring that up, stop me again.
Oh, I will. Yeah, for
okay.
Sure.
So the character and fitness review is. Oh, sorry, I got some questions here. So what if you pass the bar exam at England? Do you still need to go through the NCA or LLM when you transfer back? There will be more on that later. And I'll give you some information on what it means to get called in England. And the short answer to that is it depends. What's going to occur is that the NCA is still going to assess you. You likely won't have those exams. I can't say what they would determine for the bar. England and Canada have a very close relationship with their legal systems. And if you're called and you've been practicing there for a number of years and it's clear that you have the expertise, I don't know if they'll make you write the bar. They might, but that is something that I'm not sure about, and I think would be ultimately a decision for the Law Society. And there is actually information on the Law Society website about that. And in this moment, I'll plug the Law Society website. It's very good. It lays out the steps of what you need to become a lawyer in Canada, what it means if you get called in, say, Alberta, and you want to practice in BC, because they're different bars. I'm only called in British Columbia. I'm not called anywhere else in the country. But because it's Canada, transferring between provinces is a lot easier. And then there's also, they acknowledge what you have to do if you're called somewhere else in a common law jurisdiction and you're trying to practice here. But there will be some more information on that towards the end of the slides, and a little bit on the process of getting called in England that I think is important to know before you head out there as well. So if, again, that slips my mind, please stop me and refresh my memory that I was going to talk about that. And we'll get to that with a little more detail. So the character and fitness review is pretty straightforward. I sort of see two aspects to this. The first one is when you submit your application for your articles, there's a number of questions that they ask you. And simply put is, do you have a criminal record? And if you do, what was it? When did it occur? Give them the information on that. That's pretty much the character and fitness review. I think you have to disclose if you have any alcohol or drug dependencies, that kind of stuff. The legal profession is known to be a profession that ends up breeding a lot of mental health issues and causing a lot of alcohol and drug use. You don't get punished for it. There's a lot of good services available to those individuals that end up struggling with this. And the Law Society is very understanding of that and very aware of the problem. And it's something that the Law Society is working towards fixing. But all of that to say that, if you have something on your past, it is not necessarily a barrier. It may require some more explaining. It obviously depends on what offense may or may not have occurred. Whatever issues you may or may not have that challenge this character and fitness review. For the most part, and I think for most applicants, it's a fairly straightforward set of questions. It's not overly specific, but again, there are people that will have to explain a little bit beyond just answering the no, I have nothing on my record, and that's fine. That's not going to prevent you from being called. It may mean that you have, again, like I said, some more explaining to do, or they have to look into what your offenses may have been a little bit more. The second aspect to this is during your articling, you have a meeting with somebody called a bencher, and they're lawyers that help work with the Law Society, broadly speaking. My meeting was during COVID. I went through my articles during COVID, so all of this changed in the middle of my PLTC and my articling experience. I had a telephone call. Typically what you do is you go have a face-to-face with the bencher that you're assigned to. And these are people that, if you're ever in a position where you have an ethical question or some professional responsibility question that you don't know how to handle, or you're worried about acting in a certain way and what liability that may create for you, they're a sounding board. This meeting that you have during your articles is about what you've done during your articling to date. Have you done anything egregious that causes concern? That being, any significant mistakes that have really prejudiced a client or caused them harm. Have you misappropriated funds? That's the biggest one, really, is what you do with your trust funds. That's probably the most strictly, governed bit of practice that there is. But again, this, for the most part, should be a straightforward meeting. And I say that because when you're articling, you're assigned a principal, and that principal is a called lawyer, and they're the ones that are sort of your mentor and overseeing what you do and making sure that you don't fall into any serious pitfalls or get into any serious trouble. So the character and fitness review is, I want to say, more or less straightforward. Again, I acknowledge and understand that that's not going to be the case for everybody, and that's fine. For the most part, I think the Law Society works with the people who are applying for their articles to get through it. So that's this portion of it. For the most part, and for most people, will be answering a series of questions that forms part of your application to the Law Society to get your articles started, and then also the interview with the bencher during your articles. And then that's really it. So we can go to the next slide. So the Law Society Admission Program, this is PLTC. This is your articles. These are the two steps together. Sorry about that. So in order to qualify and get called to the bar, you need to article, which is 9 months of full-time work, and you need to complete PLTC, which is the professional legal training course, which is a 9-week course, and then the 10th week is the bar exams. You can do PLTC at the beginning of your articles, you can do it in the middle of your articles, you can do it at the end of your articles. Different people have different methods on how they want to tackle it. Some of that will be probably determined by the need of you at the firm. So especially if you go to a smaller firm, and let's say you're working at a smaller litigation firm, and there's a big file that's going through, and they need you working at that time, and they can't afford to have you go away for 10 weeks and do PLTC. When you're away at PLTC, you cannot work. So the Law Society forbids law firms from making you work during that time. You are away at PLTC doing your training course, and the law firms have to respect that. PLTC is essentially school. So I started that at the beginning of COVID, and I was in week 6 or 7 when everything shut down. So when I started, and what was standard practice before, was you go to the Law Society building, they have a bunch of classrooms, and you're assigned a teacher and a class, and you run through a wide variety of material. The difference between this and law school is a lot more theory, and this is a little bit more hands-on and practical. Within PLTC, you have 4 assignments and then 4 assessments. The assignments are marked as pass-fail, but they don't actually count towards anything. They are a practice run for your assessment. So again, 4 assignments, 4 assessments. There's only 4 different, there's 4 different things that you have to do. And I believe that's on the next slide, which we can go to. So the assessments and assignments are contract drafting or drafting assignment. You have to write an opinion letter based on a fact pattern. There's going to be a chambers application, which is a sort of a moot or a mock trial, where you are before a fake judge. You have your file, you have your case law that you're referring to and relying upon. It's contested, so there's a lawyer on the other side, and you're going back and forth, trying to advocate for your case and your client. And then there's a client interview, which you do with a fake client who is one of the members at the Law Society. And there's, basically you have no information going into it, but you have to run through a 45-minute interview to get specific information out. Then you take a couple moments and you provide them with some preliminary advice. You have to pass all 4 assessments. Again, they're pass-fail. The contract drafting and opinion letter as I was told, are the most commonly failed ones. If you fail, you will have an opportunity to do it again in the next PLTC seating. So, you know, your career's not over. You have an opportunity to work on it again. And there's some more specific stuff there that, you know, PLTC and the Law Society will get into if you end up at that point in time, and how they pass and how they grade and all of that stuff. So again, it's sort of like going back to school. And some people, based on that, elected to go into PLTC right out of law school, because in their mind, they were fresh, still a student. They knew how, you know, to study and all of that stuff. And some people elected to go work for, you know, 9 months and then to PLTC at the end of that, having gotten a taste of what it's like to be a lawyer and work in a firm and get some more hands-on experience with that. There's no right or wrong way. I could give you pros and cons for both of them. I did it, I think it was in the middle, just based on timing and when PLTC was having their seating and when I got approved and was allowed to start my articles. For me, my decision was based on how quickly can I achieve this and complete my goal. So that's, you know, again, that's a personal decision. There's no right or wrong answer with that. Maybe I would say if you do it at the beginning or in the middle, if you fail a component, you'll have time to do it again before you're done your articles. Whereas if you do your PLTC right at the end of your articles and you fail something, you're not going to be able to be called to the bar until the next seating, until you pass that. So it could be another 6 to 8 months. So that might be something to think about. I think the pass rate is about 65 to 70% for passing everything. It's a stressful time, but it's not overly difficult. It's a lot of work. You're very busy. And again, that adds to the stress. I think the fact that you're at the final stage before, you know, reaching your professional title and your goal also adds to the stress. But again, looking back on it, yes, it was very stressful, but it wasn't the hardest exams that I've written. It is very possible. It's all open book. So you have material to rely upon. So with that, I think we can go to the next slide. So the bar exam. Yeah, this was a fun experience. It's not the worst. It's open book. There's a ton of material. You're not going to memorize all of it. There's what we call indices, or various indexes for each course or each subject matter, that basically is a shortcut or a roadmap to the material within your book. I think there's 5 or 6 binders worth of material that you have to write an exam on. So there's no way you're going to memorize all of it. It's thousands of pages of stuff. The goal is to have good indices so you can see a subject, you can see a question, you know where that subject matter is in your index, you refer to it, and it tells you where to go in the page. Everybody has them, they get passed around, they get updated for every session, and it's encouraged by PLTC that you do this. So you're not cheating, you're not, you know, doing something that you're not allowed to do. It's an open book exam. You're allowed to bring whatever material in you can. And that's just how this exam's written. The exams are separated into your barristers and your solicitors. Barrister is the old-fashioned way of saying litigator. So it's all the information to do with court. So criminal, civil, family, those are all barrister subjects. Solicitors is going to be real estate, corporate, commercial, that kind of stuff. So anything that's out of court really, or non-adversarial is another way to look at that. The exams are 3 hours. And like I said, they're written in the same week and they're a few days apart. And then again, professional responsibility and ethics are 2 subjects that are intertwined throughout both exams. So that's really it with the bar exam. It's multiple choice and some very short answer. It's not essay questions. If there's short answers, you know, they're looking for a couple points in particular. I think it's more about understanding and gaming an exam, really. You know, if you have a short answer question that's worth 5 marks, you're probably looking at 5 points to bring up. If it's worth 3 marks, again, 3 points to bring up. So it's that kind of stuff. It's about speed. It's not a matter of, you know, how difficult the questions are. I think you're going to have about a minute a question, something like that, maybe a minute and a half. So you don't want to get stuck looking for something and be super stubborn. If you don't know it, move on. You have time to go back. You're not stuck in one area. You can go back and forth. So these are all things that I think on the eve of your bar exam, you're going to get a lot more familiar with people who have just gone through it, who have various, you know, pieces of advice for you in doing it. At the end of the day, trust yourself. If you've gotten to this point, you're a capable student. You know how to write an exam. You know what works for you, and you know what doesn't. Stick to your strengths. And that's, I mean, that's really all I can say about the bar exam. Again, it's pass fail. So yeah, it takes about a month after you write it to get your results, whether it's for all of PLTC. You don't get your results for your assessments during. You get all of your grades back about 4 weeks after you write your bar exam. And then with that, I think we can go to the next slide. Okay, so we had a question about getting called in England, and this sort of touches on it. So I think largely it depends. If you are, you know, one of the top lawyers in England for 20 years and you want to come practice in Canada, you know, well, first of all, I don't know that you would ever do that, but the Law Society would look at that and recognize your experience and your expertise. If you're somebody who got called, you know, 6 months before in England and you're trying to come back, they may say, okay, you've got to do, you know, the bar exam and all of this stuff because you're too new. You don't know enough yet. You don't have enough experience to properly move forward. So my best answer for that, unfortunately, is it's probably a case by case and it depends. What I wanted to tell you about getting called in England, and this is something that I learned fairly quickly. So, and this will segue into what you should be looking for if you want to come back, and also what I think is a typical process for getting an articling position as a Canadian law student. So when I went out there, again, I was in the 2-year program. They have something called a holiday scheme, and that's basically like a student position at a law firm. They call it a holiday scheme because typically you do your holiday scheme over Christmas break or over the summer break, so over your holidays. Holiday schemes are difficult to get, and typically the people that get a holiday scheme will then get a position either with a mini pupillage or pupillage rather, which is the barrister side, or a training contract, which is the solicitor side. Now, another note on this is that in England, you become a barrister or you become a solicitor. You're not both. Here, you are a barrister and a solicitor. So I am both. I can appear in court and I can do solicitor's work. In England, you're either qualified as a solicitor and you cannot practice in court, or you're a barrister and your practice exclusively is within the courts. So when I went out there and I was learning about this, I think I went out late September and applications were due, you know, mid-October for holiday schemes. At that point, you had to figure out whether or not you wanted to be a barrister or a solicitor. I had no idea. And I think most people don't have an idea. And my attitude has always been, you know, I'm open. You know, maybe I have a sense of what I might like, but it's hard for me to say whether or not I will like this because I haven't tried it. I haven't done it. You know, and the same goes for me saying that I won't like something because I haven't tried it. So making that decision that early on to stay in England and to practice there, and this will be some people's goal is to stay out there, and that is a great goal, and you should stick to that if that's what what you want. But you have to make a choice fairly early to get on the right track, and the right track being getting your holiday scheme so you can get your training contract, which is the equivalent of articling for solicitors out there. And then on the barrister side, it's a mini pupillage, which will lead to your pupillage, which is the equivalent of articling, but for barristers out there. And they're hard to come by, especially for barristers. You know, there's a stat that really blew me away out there, and that's that in England, there's more judges than there are barristers. So there's more judges to hear cases than there are lawyers to go advocate for the clients in the court. I don't understand how that's possible, but that was the stat. So if being a litigator is your dream, and doing so in England is your dream, that's great, and you should stick to it. But it's a battle, and know that going in, that it will be a challenge, and that doesn't mean you should shy away from it, but just understand what's ahead of you, and get ready for that, because it'll be a lot of work, and that's fine. But again, sort of speaking to getting called in England, you have to make a choice very early, and the training contract will allow you to get called to the English bar. Their bar program is another master's program that's like £20,000. So your law degree doesn't get you there. You have to do like a $20,000 final, and you do get a master's out of it, but to get entrance into that bar is very expensive. If you have a training contract, the law firm usually pays for that. So it is that's a very high motivating factor for me, at least, if that's your goal, is that you want to try and get your training, your holiday scheme or your mini pupillage that's going to lead to your pupillage or your training contract. So you're not going to get hit with another £20,000, so more in Canadian dollars, bill at the end of it. So be aware of that. And there's nothing wrong with that. But if you don't act quickly, you may spend a year outside of your law degree sort of trying to figure out what you're doing with work, not having your training contract in place, and sort of floating around. And if you do that for too long, you may start getting firms that look at your resume and say, well, what happened here? Why weren't you hired immediately, or even a year after, 2 years after? Why do you have this massive gap? And that's something to consider. So if you go out there, think about the pathway that you want, act on it quickly, go to the networking events, get a feel for what there is, and what you have to do to get where you want to go. So that's getting called in England. Coming back, or actually, perhaps I'll start with, if you have a Canadian law degree, or you're going to a Canadian law school, typically what happens in your second year, I think it's the start of your second year, is you get what's called on-campus interviews. So you have law firms that come to the law schools and they interview a ton of students with the goal of hiring them for a summer position at the end of their second year. So that summer position will last the course of your summer. You go to the firm, you work there. Typically, law firms hire summer students with the plan of hiring them again the following summer as an articled student. So that's the easiest pathway to break into obtaining your articles, or that articling position. And that's really the biggest challenge of all of this, is coming back and how do you get your articles, or coming out of law school, how do you get your articles? I spoke a bit earlier about Canadian law students looking down upon students to go to England or abroad, or things like that. Even within the Canadian law student, the student base, I think the expectation is that you go to a big firm. Everybody thinks that's what they do. That's what they want. They want to go to a big firm. And if you don't get there, you've failed. And it's something that a lot of people don't get. And it's something that a lot of people that don't get that have a bit of a crisis over. They think they failed. They think they haven't done good enough. They've come short of their goal, and it's absolutely wrong. Most people that have, a lot of people that start at big firms leave the firm within 5 or 6 years. They don't like it, or they have other plans. I have a close friend that she went to one of the major firms in Vancouver for 5 years, and her plan was to get experience, get that on her resume, and then she applied to a major real estate developer to be in-house counsel. And because of her experience, she was able to dictate her salary and go into in-house practice, commanding what she wanted. And that's because of her experience at the big firm. So there's benefits to it. I think a parallel I could draw would be, if you're looking at becoming a CPA, working at one of the big 4 accounting firms, I think a lot of people look at that and say, oh, that's the goal, that's what I want to do, and realize it's not. Some people probably go there for a number of years to get that experience so they can go do whatever they want. They can go apply for whatever job they want. I think there's a lot of similarities there with major law firms. And that doesn't mean that all accountants go to the big four firms. Not all lawyers go to big law firms downtown. A lot of them do. A lot of them leave. And again, that's, I think, what a lot of people envision as like the proper path. You go to a Canadian law school, you get a job at one of the big firms downtown, that's your life. That's not for everybody. That would not be for me. And I'm not saying that because I went to England. I'm saying that because I don't like a lot of the people that have, a lot of the personalities that fit that firm or that corporate cutthroat lifestyle. I don't care for organizational politics and trying to get ahead by backstabbing somebody, and it happens. It does. I've heard stories about students that would rip pages out of textbooks in law schools, in the law school library, so other students couldn't study that material and they wouldn't do as well. Like it gets to be a bit much, and I don't have an interest in working alongside those types of people. For certain people, that's where they thrive. They love it. They love the competitive atmosphere. They love the title and the status and all of that. And that's, I'm not knocking them. That's their path. That's what gets them going. And to each their own. And it's about finding what you want and what you like. And that will take some learning, and that will take some realizing that you may be down a path that you don't like. All of that to say, don't beat yourself up if you don't end up in a big firm and you've applied through a Canadian law school. So that was a very detailed explanation of what I think the general path for Canadian law students is. The challenge for people who are studying abroad and coming home is breaking into this cycle. And this is something I struggle with, and I think this will be probably, your biggest hurdle in this process if you decide to study abroad and you want to practice at home. It's how do you get your articling position? And it's hard. It's competitive. It's hard out there. And there's a few things that I didn't know that I learned. But I would say, it's probably best to start talking to family, friends now, and see if you know anybody, and let them know you're going away. And if you're going away, can you come back in between your first 2 years and, do whatever at the law firm, just so it's on your resume. While you're away, get involved in student politics, get involved with the school and extracurriculars, and boost your volunteer work. And so you have more than just, okay, I did well over here, but you don't really know what the grades are and how they work over here. So it's hard to see, really come back and try and complete yourself as a very whole and competitive applicant for these types of things. The challenge will always be, how do you apply for a program if you haven't really started your first year of school, or you've only had 1 year of school and they're only taking second year law students? And there may not be a clear or great answer to that, but I think it's important to start getting connected with as many people as you can, as early as you can, and they'll give you advice on it. My path was, I ended up being a legal intern. I'm going to walk that back one more step. I came back from law school, and then I did my NCAs for 8 months. And then once I completed that, then I got a job as a legal intern in-house in a fintech company, working under the chief legal officer. And it was a family friend. And, he needed help. He knew I needed some work, and it was just a connection that came together at the right moment. And it was good. And part of the goal was trying to get me exposed to people in the legal community and hopefully get me a job at a law firm. It didn't happen right away. Ultimately, I was there long enough that, we looked at each other and said, let's try and make this my articles so I can continue to advance myself forward. And ultimately we did. The Law Society allows students to article in-house. I was fortunate because this company used another law firm for a number of collections matters. So I was able to go there and get my litigation experience with that law firm. So, there was a relationship built. Again, I got it through family friend, and through my work there at that company, I was able to go to another firm and get experience there and finish my litigation experience and my articles, get called to the bar, ultimately got a contract extension there. And then I ended up here last summer. So, like I said, throughout this speech, it was not your standard path. It was not your unique path, but this was what I wanted. This was my goal. And I wasn't going to let certain roadblocks deter me from that. So I kept pushing towards it. And now I am where, I want to be. And I'm happy with that. So everybody has their own path. And it's about, if you're going abroad, making as many connections as you can and try and get ahead of it. The application process as early as you can. Try and get as much understanding of the process as you can. Something that I'm remembering that I learned about was the Vancouver Bar Association's guidelines on hiring articling students. I'm just going to get a quick sip of water. So the Vancouver Bar Association puts out guidelines that most downtown, if not all downtown firms follow. And I have the website. I apologize, I didn't include it in the resources I had. I'm just going to pull up the website, and it is vancouverbar.ca. So write that down. And then at the top there's a banner that says student recruitment guidelines. Actually, you know what? I'm going to just put it in the chat. This sets out a timeline that I didn't know existed. So I was looking to get an articling position, hopefully as soon as possible, in June, in the spring leading into the summer. And I wanted it hopefully for that summer because I was in a position where I was eligible. I learned that it says the last Thursday of June here, or June 30th at 11:59 is the deadline for articling students to submit their articling applications to firms downtown for the following year. So this summer, at the end of this June, you would submit your application for 2023. So that was another year of not advancing and not getting where I wanted to be, that I didn't really want to deal with. The reason I'm mentioning this now is that the vast majority of firms follow these guidelines. So if you know about these timelines, you can get ahead of that application process. You can see when the deadline is and when you have to apply. So if you're looking to do this right away, it would probably be, your as you're going into your final semester in your final year, with the expectation that you come back home right away, you pass all your NCAs, and then that following summer, you are eligible to go right into your articles. So it moves very quick. So be aware of that. There's a couple links here. So that link I put into the chat. If you open that page, it says quick nav. There's 4 links in there. Open them up, have a look, so you get an understanding of what it means, what these firms follow. There's another chart. Yes, so it's the first link, and I'm just going to copy it and paste it in here. 1 second, bear with me. So that link should work. This is, no, it didn't work. Anyways, there's a chart on the first link I sent there. Disregard the second link. On the first link I sent into the group chat, that shows the hiring intentions of a lot of the major firms downtown. So yeah, so if you click on the here button right there, this is the chart I'm talking about. So you'll see, whether or not they're going to accept applications for articling students for 2022, 2023, and so on, and how it may affect you. And again, this is information that, you can just build up and understand what the process is, so you can navigate it properly. So you're not flying in the dark. You're going to have enough, if you're going abroad, hurdles coming back, sort of explaining why you went abroad and all of this stuff. That, it's good not to have these other things working against you. So this is something I wish I knew before. I didn't. Ultimately, it was fine. This is for the Vancouver Bar Association. It is voluntary, so these firms do not have to follow these guidelines. The big firms, I think, are large enough that they do. It would be unusual for a big firm, perhaps not unheard of, but unusual for a big firm to have a sudden need for articling students that wasn't pre-planned. I think usually they're looking at hiring students and what they may need resource-wide, probably a few years in advance. So that's why I mentioned this now. This is good information to have now and think about while you're in it, because for me personally, when I was going through it, I thought, oh, it's way too premature. I'm not even done school. How can I be thinking about getting a job? But I wish I had a little bit more. Ultimately, I don't think I wasted much time. I think that's a byproduct of me being open to taking an alternative path to getting called. If I had been dead set on getting a job at a big firm, I probably would be getting called, a year from now, or this year, or at least a year or two after I did. So again, I think keeping an open mind and understanding what your goal is. If my goal was to get called as soon as possible and get working. Some people's goal may be that I only want to work at a big firm. And if that's your goal, that's what you should work towards and do what you need to do to get to that point. And that may not be taking, the most creative route to getting called like I did. That's something that, you as an individual will have to do some self-reflection on and figure out and act upon that. So that's my ramblings, probably for way too long.
Jonathan, just a quick summary of what you think, now that you're in the position of law, what do you do, all day? I mean, we chatted about this.
Yeah.
You have to dispel the myths.
I think it'll depend on the path you go down. I think, perhaps a negative way to describe what I do is a glorified editor. I do a lot of reading, I do a lot of writing, I do a lot of editing. And that's the day to day, and that's fine. I mean, I expected that. I didn't go into law school thinking that I was not going to have to read a bunch of stuff or do a bunch of writing. I mean, it's a big part of it. It really is. And I wasn't really disillusioned by that. I have people ask, oh, do you love it? Is it really interesting? Some of it is. Some of it's boring, and that's fine. I'm not put off by that. I expected it. My hours at this firm are very reasonable. But generally speaking, I work 10-hour days. I have lunch on my computer. I do have breathing room. I'm not, glued to my desk. But as far as being a lawyer goes, I have a very cushy day to day. Some lawyers are working 14 hours, especially early on at a big firm. You are working a ton, and people are pouring work on you. And some people, again, love that. They thrive on it, but it's a lifestyle. If you're at a big firm, you may get called in every Saturday. There's partners that are still working Saturdays. And I had a family friend who's a lawyer, and he and I had a conversation early on, and his attitude about big firms were, he had a colleague that he probably estimated was at that point in his career making $2 million a year, which is obviously a wonderful salary to have. But, he was in his 60s and still working Saturdays. He'd been through a marriage and was on his second marriage. And then there's other health issues that come with the high stress and all of that. So these are real things to think about. It's not just salary. There is a lifestyle aspect to it. And more, I think people, as they get younger and younger, are a lot more aware of a work-life balance and what it means to them. And it is available. I mean, I don't really work weekends unless I want to, or unless there's something really urgent. But I generally don't have to work weekends. Again, I have a 10-hour day. That's probably longer than most people, but it's not that crazy. It's not 14 hours. I'm not sleeping in my office and doing that kind of stuff. And you do hear stories about that. So that's my day to day. Another note on going to law school. It's a lot of work. It is a lot of work. It's high stress. So, if you're sort of on the fence, really think about it. It's a financial commitment. It's a time commitment that if you're making the choice, you're going to dedicate 2 to 3 years of your life doing school alone, and you will come out financially worse off on the other end because of it. You will have access to a very secure profession that pays well. So, over the long term, that debt is not necessarily, too overpowering or overbearing, but, I think you have to really think about if it's what you want. And even if it's not, like, that's not, the end of it. A law degree, I think, is a very versatile degree where it's widely applicable in business and supports business. And if you are an econ, you have some disposition to that. The other thing that was becoming quite popular when I was going out there was the big 4 accounting firms are now branching out and becoming, I think it's something like the fastest or most rapidly expanding law firms, because they're opening up legal departments now within there. So big companies can go to these firms and it's a one-stop shop. So if you're still thinking, finance maybe, or law maybe, there's a career where there's both, and that can be a very lucrative career. So there's options there. There's things to think about. And I think it's worth spending the time thinking about what you may want, what you may like, but also being realistic about what it means. And that's, you're going to have to put work in. It's going to be time consuming. It's going to cost you some money. And your job on the other end it's going to be work. If you're in litigation, it's going to be a very different story. You're going to have the thrill of going into court, but if you don't like performing or public speaking or anything like that, litigation is probably not for you. And again, that's fine. There's tons of other avenues you can go without having to see a courtroom. I've been in, court once, and I don't plan on going back. So, I got my experience doing that. It's part of my articles. But I knew that, as high as it was coming out and getting the order that I saw it, it's not what I wanted for my day to day. So I think to a degree, it's about knowing yourself and what you can withstand, and being real about what the profession is. And for those of you that lasted the hour and 40 minutes, thank you for making it to the end. I know there was a lot of information and a lot of talking and all of that. So I hope it was valuable. I hope it was useful. And best of luck, really. If this is something you're interested in, I really do encourage you to do it and go for it. For me, it's been totally worth the pain of going out there, the financial burden and all of that. I'm very happy I did it. So I recommend looking into it and trying to find your path.
Fantastic. And so I think everyone else here is really appreciative. Jonathan, thank you very much. Carmen, thanks a lot. And we'll talk soon. Jonathan, I'll probably connect with you later.
Yeah. All right. Thank you. Thank you, everybody.
Thanks, guys.